Hello, welcome to today's program of the Ethical Humanist Society of Chicago. I'm Anil Kashyap. I'm a member of the Society and I'll be moderating today's program. We're meeting virtually out of concern for everyone's health and safety. We look forward to being able to resume our in-person meetings when it's safe to do so. And in the meantime, we're grateful to be able to connect with each other on Sunday via our YouTube channel. If you're new to us, our group is a member of the American Humanist Association, and the AHA defines humanism as a progressive philosophy of life that, without theism or other supernatural beliefs, affirms our ability and responsibility to lead ethical lives of personal fulfillment that aspire to the greater good. Our programs address a wide variety of topics, including current events, philosophy, arts, sciences, just to name a few. Today's presentation is part of our ongoing program related to politics. To deliver it, we're delighted to have Tonja Jacobi to speak to us. She's a professor of law at Northwestern Pritzker School of Law. She has a PhD in political science from Stanford, a master's from Berkeley, and did her undergraduate work at the Australian National University. Her research focuses on judicial behavior and the strategy in public law. Her areas of interest include judicial politics, Supreme Court oral arguments, criminal procedure, and constitutional law. Combining doctrinal, empirical, and formal analysis, she examines how judges respond to institutional constraints. She's published in all the top journals, and is a co-founder of SCOTUS OA being oral arguments.com, a website devoted to the empirical analysis of Supreme Court oral arguments. I encourage you to check that out. It's pretty cool. So without further ado, here's Tonja, and we'll be back for questions after she concludes her prepared remarks in about 40 minutes.
Thank you, Anil, and thank you all for having me. I'm really pleased to be here and to address you on the Supreme Court. I'm going to present today on oral argument, and essentially I'm going to show you the ways in which we can see how political the court is by examining one aspect of the decision-making process, where the court hears advocates actually come before them and make their oral arguments in addition to their written briefs. But during question and answer, I'm happy to take questions much more broadly, not just on what I present, but on other aspects of Supreme Court behavior. So, for example, we've had some pretty contentious nomination processes in recent years. I'm happy to talk about that. Also, particular directions of the Supreme Court, the fact that the court is much more conservative than the general population these days and what that might mean. In particular, given the ethical humanist focus, we might talk about the possible and the current and possible future, even greater turn towards religiosity in the Supreme Court's ruling. So I'm happy to take a broad range of questions. But what I'm going to talk to you about today is about oral arguments. And the topic, we called it How Justices' Questions and Jokes Can Predict Supreme Court Rulings. And what that really means is, can we empirically look at this one public part of the Supreme Court's decision-making process? Everything else is done behind closed doors. We don't know what they talk about when they get together and discuss the cases. This is the one area where we get to see what the justices' concerns and questions are and so on. And what can we tell from that? And essentially what I want you to take away is that we can show just how political the Supreme Court justices are and how they are increasingly so. And I'm going to talk about why that's the case as well. And the jokes part is, I want to talk about that in particular, partly because it's fun, but also because I think there's a tendency for us to sort of fetishize the justices a little bit, to take, to really reify them. So, for example, on the left, it's been Ruth Bader Ginsburg. On the right, it's been Justice Scalia. And to sort of treat them as these sort of demigods. And I think that that's quite problematic. And so if we look at something like jokes, which is sort of adding to their charm and charisma, but actually I'm going to show that's part of their politicization as well. So sorry to kill the fun of the jokes, but we'll look at some of it. And it is funny, but at the same time, it's also pretty concerning. If you believe in the rule of law and if you believe in judges not just acting as politicians. All right, well, with that, let's get straight into it. I'm going to try and address 4 questions today, time allowing. The first is why are Supreme Court arguments so fraught? And so there's this sort of back and forth, there's interruptions, there's talking over the top of each other, there's really tough questions. And I want to ask, why is it so much like that? And people talk about oral argument being very different these days. And the answer I want to convince you of is that it's essentially because the justices are engaged not just as judges, but as advocates for particular policy positions. And we're going to show how we can measure that. The second question is, what does laughter mean? And as I mentioned, we sort of see this as part of the sort of idiosyncratic charm of particular justices. But what I'm going to try and convince you of is that laughter, the use of jokes by the justices, is actually another form of political advocacy as well. The third question is about interruptions. Now, you may have heard about this. Some of my research in this area got a lot of international and national attention, showing that the female Supreme Court justices get interrupted much more than the men. And it's the response was sort of, even if you make it to all the way to the Supreme Court, you're still treated as a woman first. So I'm going to show you some of those results, but also more generally, and we'll get into particular gender issues before the court. And then finally, given the current era, what did the pandemic do to oral argument? And I'm going to show you my most recent research showing that it actually was a forum for the Chief Justice to exert even more power, and particularly to give advantage to the conservative justices, and also to interrupt the female justices some more. Okay, let's get straight into it. So what I'm going to do today, the analysis that I'm based on, I'm going to empirically measure a whole bunch of things that happen by looking at the transcripts of every oral argument done before the court starting in about 1955 and looking to current day. And so this is what the transcripts look like. If you go to OYE, you can follow along oral argument in real time. You'll listen to it, and then it highlights where the person is talking. And so, for example, you can see notations such as this dash dash and this dash dash here. And essentially, I'm going to quantify that. So this, when a dash dash is in the middle of a sentence, that's just a stutter. It's just that somebody's searching for the right words. But when it appears at the end of a sentence, that is an indication that there's been an interruption. So here, Justice Kagan is interrupting the advocate. So we can measure a whole bunch of things like that. Even things like, does the sentence end in a period or in a question mark? And then that's going to give us a measure of questions. So that's what we're looking at. And I really encourage you to go to OYE if you're interested in the Supreme Court and listen to some oral arguments. The current ones are not so interesting because they're done on the telephone and there's not the same dynamic interaction. But hopefully we'll get out of the pandemic soon and it'll go back to normal oral argument. And it's really quite entertaining and it's really quite insightful. You can see my argument, as the title suggests, is you can actually often predict Supreme Court cases based on what happens at oral argument before anybody's voted. And so there's even some money to be made on the stock market potentially in some cases if you start paying attention. All right, question one, why are Supreme Court oral arguments so fraught these days? All right, I'm going to play something for you and just have a listen. First of all, we've got Justice Sotomayor speaking to an advocate.
Correct. So it's not negating Congress's purpose if a district court gives 1 day, correct?
I would say not, no.
And 1 day is a day of punishment, isn't it?
No question as to that, Your Honor, yes.
Isn't that your point?
Basically, it is that.
Okay, so as you heard there, Justice Sotomayor is helping the advocate in this case. So she ends up voting for the side that Alan Stoller is arguing, and you can say, she's essentially saying, aren't you saying this? And he's like, oh, yes, correct. And so doesn't it follow that, your conclusion that you want? And he's like, oh, yes, yes. So she's helping him. But it's hard to measure that. But here's an unusual statement by Justice Kagan. It's a bit quiet at first, so listen carefully.
That as Justice Kagan and I discussed, 1 day is an additional punishment. In 1 day, I'm sorry, the wrong end.
Helping you.
I'm sorry.
I was the one who wasn't.
So what Justice Kagan, so Alan Stoller confuses Justice Sotomayor and Justice Kagan, which happens among the female justices all the time. They don't look at all alike. This was back before it was on telephone, so there's really no excuse. But what he says is, as Justice Kagan and I were discussing, referring back to the previous comments, and Justice Kagan says, no, she's Justice Sotomayor. She's the one who was helping you. I'm the one who's not. And so this is an actual admission by the justice that another justice was actually going out of her way to help an advocate. And the justices normally pretend, oh, we're inquiring, we're asking tough questions, but we're completely fair and balanced and we have no, preconception. And that's sort of an admission that that's not the case. And I think most people agree that it's really not the case, especially in, the highly salient political cases. But there we have an actual admission of that happening. All right, so now I want to show you how Supreme Court oral argument has changed over time and how this sort of advocacy, which this helping was just one example of, how that's changed over time. Okay, so how has oral argument changed? You might have heard that Justice Thomas basically never speaks at oral argument, right? And some people say, he's failing in his job as a justice. Part of his role is to get in there and ask questions. Okay, so what this graph shows is how often justices have been silent over the years of the Supreme Court. And so what you see is these solid circles are Justice Thomas, and all the other empty circles are various justices throughout time. And what you can see, I'm sure, is a big shift that prior to about 1995, it was very common for justices to be silent for at least part of a term, or up here, we see a proportion, the average case, justices who are silent an entire term, right? And so that was not unusual. Now, Justice Thomas is unusual in that almost every term he's practically silent, or like up at 1 means 100% of the time he does not speak. And you can see, the most he gets down to is, he doesn't get down to 0.9. So in 95% of cases, he's silent, and often 100% of cases. So he is a bit unusual. But what you see is that this area is empty now. All of the other justices, it's very, very rare for them to be silent. And so we've seen a change at oral argument. So even though Justice Thomas is unusual, in some ways he's sort of from a different era. And so where does this change take place? It takes place around about 1995. And I'm going to talk about why that's significant in a moment in terms of what has happened and what has caused the Supreme Court to change its behavior. Okay, so here's another measure of the way that the Supreme Court has changed. Here we're looking at the number of words spoken per case by the justices in the solid circles and by the advocates in the empty circles. Okay, so pay attention to down here, the justices. We can see that around about 1995, there was a big jump from around 2,000 words per case to closer to 4,000 words per case. A little bit of an increase before that, but nothing really significant. It was really around about the mid-90s that we had this big jump upwards. So that means in a 60-minute oral argument, which is standard, the justices are taking up 13 additional minutes. So almost a quarter more of the time than they were previously. So a huge increase in judicial activity at oral argument. And correlating with that is a drop in advocate activity because, there's only so much time for everybody to speak. Now, some people say that oral argument change, it became the way that the justices interact so much more actively now, is a result of Justice Scalia joining the court. He was this big personality and he changed everything. Now, Justice Scalia joined the court in 1986. And you can see that there wasn't really much of a change, maybe a slight increase starting in the early 90s, but the big shift happened in the mid-90s. And so one thing I want to convince you of is that Justice Scalia is given too much credit for being like this force of change. He's not as important as some people would want you to think. And so it's very easy to sort of look at personality-driven explanations for what happens in institutions, but really it's much more about institutions and structure. And what I'm going to show you is a political explanation as to why we have this big shift. So throughout the early figures I'm going to show you, look for whether there's a change in 1986 versus 1995. And there's only one change that really starts in 1986, and it doesn't reflect well on Justice Scalia. So we'll get to that in a moment. Okay, so the justices are becoming much more active at oral argument around about 1995. Here we're looking at interruptions, and we can see another big shift happening in interruptions. So this is the justices interrupting one another or the advocates. Now we see that there's a fair bit more variation here. These dots are more spread all over the place, but at the same time we see the average shift is up from about less than 40 interruptions per case on average to closer to about 55. So that's another big change as well. So the justices are becoming active and also interrupting each other. And that's what I mean by the oral argument being fraught, like everybody talking at once and trying to make their points. Okay, Is the explanation something about the docket? We might think, oh, well, there's just the Supreme Court so important, it's taking all these cases and they want to say so much. But that's not really reflected in the data, in that if you look at the number of cases that the Supreme Court takes, now remember the Supreme Court gets to choose its docket, it gets to choose which cases it has. And we've seen a massive shift downwards from about 175 to about 70 in recent years. So the Supreme Court is choosing to take less than half the number of cases it used to. So it's not that it has so much to say necessarily. And I actually think this is part of a conservative shift. So Chief Justice Rehnquist became Chief Justice in 1986 as well. And we do see a shift downwards there. And that's when Justice Scalia joined the court became more conservative. And one push by the conservatives is to make courts less important, because what do courts do? They step in and they protect rights of individuals, they control the states and so on. And so by actually having the court do less, in some ways that's a conservative goal as well. So people who are now pushing for jurisdiction stripping of the court, given how out of line the court is, you have to think about that in terms of, well, what are you giving up? But one of the things you're giving up is the power of the Supreme Court. And so that has political significance. All right, so if it's not that the number of cases are, that the Supreme Court wants to be so active, what is it? Okay, the next picture I'm going to show you is complicated, but I'm going to talk you through it. All right, so this is essentially my political explanation of what's happening. You'll see this is the House and this is the Senate, and the pictures are practically identical. So just look at one. We're going to look at the House. Okay, so what is happening? Here we've got two different things being graphed at once. One is what's called polarization in Congress. So this is Congress. We're stepped away from the Supreme Court for the moment. And we can see that if you look at the mean ideology, the average ideology of members of Congress here on the left in the House we're looking at, but the same for the Senate, it's gone from being pretty close together to being hugely far apart now. So that means that the Democrats have shifted to the left and the Republicans have shifted to the right. Okay, and so they're much further apart. They're politically polarized in Congress, right? That's what that first graph shows. And you can see it's the same in the Senate, right? In the House, when you look at, the proportion of moderates here, we used to have a majority of people who were considered moderates. And now that's gone massively down over time, such that we basically have no moderates. So as well as both parties being to the extremes on average, there's very few people in the middle. And that's why we've got this sort of huge anger and division in the country, because we've got these two extremes fighting each other and no compromise room in the middle. And the same thing can be shown in relation to public opinion, which changed shortly after Congress started changing. And I'm happy in question and answer to talk about what caused that, but I'm not going to do that here just because it would take us too far astray. But in terms of what we see happening, there's some shifts. Essentially, party polarization started somewhat in the 1970s. But the real shift, look at this huge drop around about the mid-1990s and this huge increase around the 1990s. So 1995, there was this huge polarization. Essentially, the 1994, we called it the Republican Revolution began, and there was changes in Congress, and I can talk about what happened. And the important thing is that most people agree that polarization started in the 1970s, but it hugely increased in the mid-1990s. So that's why we're looking at the Supreme Court and what's happening in around about before and after 1995, because that's when we see Congress changing and the public changing and becoming more politically polarized. And essentially the court is reflecting that. Okay, well, let's see how it affects the court directly. Okay. All right, so we've seen that the justices are talking so much more, right? 13 more minutes out of 60 minutes in an argument. So you might think, okay, well, what's the point of oral argument? According to the Supreme Court, if you go to the Supreme Court website, the purpose is for the justices to ask the advocates questions. Okay, let's see if that's what happened with all that extra time they have. Here are questions in the solid circles, and you'll see it's completely unchanged, right? No increase in the number of questions. So what are the justices doing with all that extra time they're taking? They are making comments in the hollow circles. And we see this huge increase in the number of comments that the justices make during oral argument. And you can see this big shift in starting in the 1990s, this big jump between these two bars. These are confidence intervals, by the way, 95% confidence intervals. Now, here's the one graph where we do see a noticeable increase starting in 1986. when Justice Scalia joined the court and when Rehnquist became Chief Justice, and big conservative movements. So we do see the one area where we see an effect starting in 1986, this is the only area, is the turn from the justices to making more comments instead of questions. And so if Justice Scalia had an impact on oral argument, it was that. It was to turn towards greater judicial advocacy in the form of, making statements and conclusions. Here's my position, essentially, rather than asking a question. But nonetheless, even if that's true, we see a big shift upwards, nonetheless, starting in 1995 and continuing. The trend is still upwards. Right, so I think that's really good evidence that the justices are engaging in advocacy. Okay, what other evidence do we have of that? All right, this is complicated too, but I'm going to explain it. All right, so if you're talking to an advocate, you're a justice and you're talking to an advocate, you are essentially using up the time in which they get to speak. They only get half an hour each to make their case on this issue of such significance that it's before the United States Supreme Court, right? And so the more the justice speaks during the time of an advocate, the more they suck up their time. And so what we theorize is that the justices would do this. They would talk more during the time of the advocate that they're opposed to use up that time, to argue with them, to put these comments forward that contradict the point that they're putting forward. And so therefore we would expect to see the justices talking more during the time of the advocate who they ultimately vote against. Remember, nobody's voted. This is oral argument happening first when the justices are supposed to be deciding cases, and yet we can see that already showing who they favor. And that's exactly what we see in the picture. So here in the solid circles are the justices, the amount of time the justices talk to the advocate that they ultimately agree with. Now you can see a little bit of an increase in 1995 because they're taking up a quarter more of the oral argument. But what we see is this huge shift upwards in terms of the amount of time the justices spend talking to the advocates they disagree with in the hollow circles. Now, there's always been a gap, right? It's always been the case all the way back to 1960 that the justices talk more in the time of the advocate they disagree with, because the Supreme Court's always been a political institution, right? But now it's a massively big difference, like 150 words compared to about 350, right? So more than doubling the amount of time you speak to the advocate that you ultimately are going to vote against, right? So that, I think, is the second big part of evidence of judicial advocacy. Now, when we do regression analysis, we can show, and I can't really graph this because it's too many things going on at once, but we can show that not only are they talking during the time, but this questions versus comments effect and this talking to friends versus foe effect combine such that the time that the justices spent talking to the person they ultimately agree with, they're asking questions. The time they spend, much more time talking during the time of the advocate they disagree with, they're making comments overwhelmingly. So there's this interaction effect as well. Okay, so hopefully that has convinced you that the justices are more than ever engaged in advocacy for a particular point of view. Okay, so now let's turn to laughter, something that should be completely different, but I'm going to show you that it's really not. It's just a form of advocacy as well. All right, one thing that we did in this article, and I'll show you the sources for these at the end, is we went through and we looked at different types of laughter. And here's an example of judicial advocacy. So this is the second ACA case, and you've got Chief Justice Roberts talking to an advocate about what happened in the first ACA case, where he had a slightly different position.
Mr. Carvin, we've heard talk about this other case. Did you win that other case? So maybe it makes sense that you have a different story today.
So there's Chief Justice Roberts saying, yeah, you're changing position, but maybe there's a good reason you're changing position. He's helping the advocate out and saying, let's not hold you to the position you held before because you didn't win, and so it's all easily understandable. All right, the second way that the justices use laughter is to basically show their power position. Here's an example from Justice Scalia.
Wow, that's my comment.
So that's Justice Scalia saying, wow. That's all I have to say, wow. Which is, really sarcastic and kind of just putting the advocate down. And I read through over 10 years of transcripts, like every single instance of laughter. And people used to talk about how funny Justice Scalia is, but a lot of it's like that. It's just kind of sarcastic meanness, to be honest. And so we talk about laughter as a form of sort of superiority. Okay, the third category I want to introduce you to is self-deprecation, which is rare. And Justice Breyer and Justice Kagan are pretty the only ones who do this. This is a pretty fun snippet. Have a listen to this.
Go back to Justice Kagan. Don't forget her question.
I've forgotten my question.
I was facing the same dilemma, Justice Kagan.
But let me ask the question that I asked, if you permit. It just seems.
It's what it means to be the junior justice.
So Justice Kagan is being self-deprecating there. She's saying, I'm just the most junior justice. Everybody interrupts me. Even, Justice Ginsburg interrupts me. And it is funny, but at the same time, it's also saying, look, there's power dynamics even at our level, not just between the justices and the advocates. All right. So here's the count of every instance of laughter since 1955. So just pay attention at first to the blue, the solid blue area. And you can see, once again, there was a little bit of an increase starting in the late 80s, but a big, massive shift upwards starting in the 1990s and pretty consistently since then. So we see a lot more instances of laughter at the same time as I just showed you all the advocacy that was going on. All right, so that could be coincidence, but we'll look more closely. But just the sheer numbers support in terms of laughter occurring a lot at the same time as judicial advocacy. Okay, the second thing to note about this graph is that if you look at the dashed line with experienced advocates, it's quite low, whereas novice advocates, it's very high, right? So most of this increase by the blue is being driven by laughter at novice advocates. And so this, I think, is an example of laughter being used as a sign of superiority. They're making fun of the newbies, essentially. And partly I wanted to do this in response to somebody wrote an article saying, oh, look, laughter is an equalizing force at the Supreme Court. And I'm like, no, it's not. It's a mechanism of saying, stay in your place. Okay, so who's the funniest? We used to hear a lot about how funny Justice Scalia was, and Justice Breyer was the second most funny. And then we had, Rehnquist and Roberts, the chiefs, people laugh at their pretty weak jokes, to be honest. Okay, so that's fair. But at the same time, we can also say who makes the jokes at the advocate that they ultimately disagree with. So just the way I showed you that the justices talk more during the time of the advocate they disagree with, they make jokes at the expense of the advocate they ultimately vote against as well. Who are the ones that most show this difference between who they're making fun of? Oh, look, Justice Breyer, Justice Scalia, and Chief Justice Rehnquist are right at the top. Okay, so laughter is not just equally divided according to the spur of the moment. It's being directed in the same way as the justices are using at the time of the advocates. They're also making jokes at the expense of those advocates. Now, one of the few justices who appears high on the laughter lift, Justice Gorsuch, and who appears low in terms of the gap, doesn't mean he's not political, because you can do the same thing with interruptions. Who are you interrupting the most? And the best predictor of how Justice Gorsuch is going to vote is who he interrupts. So laughter is not such a good prediction, but interruptions are. So, we can still predict what Justice Gorsuch is going to do pretty easily. Okay, so that was looking at each individual justice. This is a way of aggregating it. So anything that's below the line means that the court overall in this year has made jokes at advocates. Every single justice has made jokes at the expense of advocates they disagree with. And anything above the line is where there's more jokes at the expense of advocates they ultimately agree with. And you can see overwhelmingly that it's a pretty good way to predict how a justice is going to vote as to who they're making jokes at. Right? And it's increasingly so. And yeah, it started a little bit in the 1980s increasing, but look since the 1990s how enormous it is. It's a very, very good predictor of how a justice is going to vote, is who they're making fun of, one advocate versus the other advocate. And you can do the same thing for the court overall. Are they making fun of people who are winning or losing? So not just how any individual justice is going to vote, but who's going to win the case. You can predict who's going to win the case almost all the time. This is a little bit less reliable. You do see a few things above the zero line, but overwhelmingly, it's pretty easy to predict case outcomes based on who's being made fun of. All right, and here I'll just show you very quickly. We see a lot of upward trajectories of justices. And so it's not just Scalia joined the court and suddenly he got all these laughs. We see this great increase, and even Justice Scalia showed an increase over time as well. So things were changing over time. Here we have the 1995, much higher than even Justice Scalia was in the 1980s. All right, how are we doing for time? I just want to make sure I don't talk for too long. Were you doing okay, Anil?
Yes, you have 15 minutes.
Sorry?
Yeah, you have 15 to 20 minutes.
Okay, that's perfect. All right. Okay, let me get back to it. All right, so the third thing I want to talk to you about is interruptions. And we're going to see very similar patterns, but here I want to particularly draw your attention to the role of gender. And essentially the short story is we do see a little bit of effective interruptions. More senior people interrupt junior people, but very, very small. It doesn't explain a lot, even Justice Kagan's joke aside. We do, however, see very big effects for ideology and gender. And so I really want to focus particularly on the gender stuff because we see ideology everywhere. It's at the Supreme Court, the role, liberal appointed justices versus conservative appointed justices. All right, so let's see what the effect is. First of all, the thing to note is that an advocate is never supposed to interrupt a justice. In fact, the moment a justice starts speaking, they can interrupt. An advocate is supposed to stop speaking, right? That's the official rule. Let's hear what happens in actual fact. Here's just one case example.
What you're saying basically is this is what the Fifth Circuit concluded, in which the school basically agrees, okay? If you don't consider race, the holistic percentage, whatever it is going to be virtually all white.
And that is incorrect. And that is an assumption that has no basis in this record.
Oh, but
it's a
there is.
stereotypical
It's not.
assumption. That's
It's
what it is.
not, because the
with all
reality
deference
that Justice
to Ryan,
Alito wants to rely on. Let me finish my point. He's right.
Okay, so you can see that Bert Ryan was not respecting the rule, that he was just talking over the top of Justice Sotomayor so much that actually Chief Justice Roberts stepped in and said, be quiet. And Justice Sotomayor said, let me finish, which is a pretty harsh language from a justice. Like that's saying, you are not following the rules. But what's amazing is how often the advocates get away with this, and in particular the male advocates. So when I did this study first in 2017, it was you could barely count the number of times a female advocate interrupted anyone. And so not only were the female justices being much more interrupted, both by the other justices and by the male advocates, but the female advocates didn't interrupt anyone. So we see a gender difference both in terms of who is interrupted, the female justices, and also who does the interrupting, the male advocates. All right, and so I'm going to show you some more updated analysis of that as well, but essentially, here's what it looks like over time. So here we've got the ratio of male to female interruptions. And so anything that's above the one line means that women are being interrupted more than men. These are the justices. There are 2 years in which that's not true to a very small effect, but every other year, the female justices get interrupted proportionally more than the male justices, even. And it's, it's only increasing over time. I'm doing an article on whether it's dropping off after, this is when my article came out, and whether there's been a decrease, it's arguable. But this is a big effect. Like it's so consistent that the female justices are getting interrupted constantly by one another when they interrupt one another, right? This is justice to justice interruptions. And by way of contrast, I want to show you data from the Australian High Court, which is another area that I studied a little. Okay, and just to show that this is not normal. So here we have female justices being interrupted, and here we have male justices being interrupted. And you can see that there's just not the same effect. Like sometimes it's men, some years it's men, sometimes it's women. You can ignore these lines, either just the era of which Chief Justice. And so it's not normal that there's difference in the way that the justices are treated is dependent on gender. Okay, coming back to the US, now let's look at advocate to justice interruptions. And we see the same effect. So before we looked at justice to justice interruptions, and now we're looking at advocate to justice interruptions. And you can see that in every single year, the female justices are being significantly more interrupted than the male justices by the advocates. There's a couple of years where it's almost the same, right? These 3 years, but a lot of the time there's a big difference, and overall the effect is quite large. Right. Getting back to Australia, unfortunately, this is normal. So interruptions of justices by advocates, and here we break down by male versus female. This is male advocates and this is female advocates. And so you can see that the difference in advocates is really huge there as well. So there are some things that are international, but some things aren't. And if you look at the biggest predictor of this is just the fact that there's so much domination by male advocates. So note the scale here just goes from 50. So we have seen an improvement in the percentage of women joining the court. This is the percentage male, and it started off at 100%, and now it's dropped down to about 82%. So we still have a long way to go in terms of, representation of women at the court in terms of advocate appearances as well. Okay, does this matter? This is a very complicated slide, but essentially this looks at when you are interrupted, are you more or less likely to agree with someone? And this is the zero line. And as you can see, overwhelmingly, all of the justices but 4 since 1960 are to the right of the line. So essentially what this means is that justices are more likely to not vote together when there's interruptions. Now, we don't know which one's cause or effect, right? Do interruptions show that there's this conflict, or does the interruption cause the conflict? Either way, the justice is being interrupted and not getting to ask their questions, and I'll show you more about the impact of that. But it also means that it shows a sign of disagreement on the court as well. Okay, I'm not going to spend more time. I know that was a difficult slide to look at, but don't worry about it too much. Okay, so how do women adapt to the fact that they are interrupted so much more? One thing I wanted to look at is how does women's language get affected by the fact that they're interrupted all the time. So what I did is I looked at politeness, and I looked at words like, I'm sorry, excuse me, may I ask, or can I ask, or using the advocate's name. And essentially it's not just polite, it's the sort of, I call it throat clearing. Women tend to say, may I ask a question? And then they ask the question. Men tend to just ask their question, right? And during that time where they're saying, may I ask a question, somebody else jumps in and interrupts. Okay, so what happens over time? The use of this polite language decreases in, I haven't done this for Barrett yet, she's too new, but in the 4 prior female justices, 3 of the 4, except for Justice Sotomayor, who started off very low in that language, had significant decreases in the amount of polite language that they use. Justice Kagan particularly, she still does it. You can still see she's a little bit higher. The average man comes to the court at 0.1, right? Every other woman drops down to about 0.1 over time. Justice Kagan hasn't quite got there yet. So essentially, women are learning to speak like men, right? They're learning to be more assertive in their speech and less polite. So what happens with interruptions? Women change the way they are and they act more like men. You can see a slight increase. I'm not sure it's significant in Justice Sotomayor. And I think this is actually driven by her saying, I'm sorry, in a slightly sarcastic way, saying, I'm sorry, but no, that's not right. So that changed, there are different ways of using the term I'm sorry. But you can see that she's still basically come in sort of at the male low levels of politeness. All right, has there been improvement in terms of the gender differential? Because obviously you can't read this very well, but I've colored them female orange and male blue. And this was just 2018 term after we did our analysis, our original analysis. And you can see actually that the women are starting to interrupt more. It's pretty evenly distributed. And here, Barbara Underwood in this term was actually the advocate who interrupted the most. She was arguing the baking case in the gay rights case. So it was a very contentious one. But so maybe there's been a bit of improvement in that female advocates are starting to talk more like men as well, i.e. they're interrupting as well, which maybe is not such a great thing, but at least it's more equal. But when you look at the justices in terms of ranking who's being interrupted, Justice Kavanaugh in recent years was #1, but in every other year since she's been on the court, Justice Sotomayor has been interrupted. And so you might be thinking, well, it's not just any woman, it's Justice Sotomayor, and that is right. She gets interrupted much more. And I personally think that's got to do with race and ethnicity, as well as some other things, which I can go into in detail in question and answer if you're interested. But Justice Sotomayor is being interrupted far more than anyone else in every year until Justice Kavanaugh joined the court. And he was pretty slow to figure out how to he was a little timid at first in 2018, but he's still being interrupted in 2019. So there we go. All right. Final question, what was the effect of the pandemic? And to show how the Chief Justice used this to give himself more power. All right, so in terms, here we look at the number of turns each justice has. And this grey bar on Justice Roberts, we've coded out when he's speaking, but he's really just, we call it traffic. He's saying he's introducing the advocate or telling somebody whose turn it is to talk or whatever. So it's not really speech in the same way. But it's important to code because that's actually where all his power is taking place. All right, so here we have, and this is going to be consistent in most of the graphs, the telephonic cases in 2019 on the left, the in-person cases in 2019 before they went telephonic, and the previous year as well when we had the same makeup of the court. I'm going to do this for 2020 term, but I haven't done it yet, but I will show you some updated information. Okay, so it looks like it's really much more equal now, right? Everybody gets pretty much the same number of chances to speak compared to in the in-person cases, it was much more even. Okay, that is a completely false impression. Okay, that is formally equal, but it's not really meaningfully equal. Let's look at the amount of time that each justice actually gets to speak with the advocate, the extent of their dialogue. In the in-person cases, you could see that the liberal justices were very effective at getting themselves a lot of time to talk to the advocates. And if we show over time, I don't have this graph, I don't think, maybe in the extra slides, whoever's on the losing side of history, so the liberals have been on a conservative, we've had a conservative court since 1970, and since then the liberals have talked more. Between back in the 1960s when the court was liberal under the Warren Court, the conservatives talked more. So whoever's sort of on the losing side of history at the time talks more, and we can see that in these in-person cases. But we switched to the telephonic cases where the Chief Justice gets to say who speaks at any time rather than everybody jumping in when they feel they have a question. And you can see it looks very different. I've got these coded black for conservatives and grey for liberals, and we can see a big shift. And how does that actually translate in terms of, who gets more time and who gets less time? Obviously, Justice Thomas got more time because he was finally speaking, but every single conservative justice benefited in terms of the amount of time they got. And every single liberal justice actually got less time than the conservatives in comparison, less of an increase. Everybody spoke more because the oral arguments were longer, except for Justice Breyer, who actually went backwards, even though the oral arguments were almost 40% longer. So in terms of how the Chief Justice was exercising this power to say who gets to speak next, the conservatives were benefiting. Okay, so what are the conservatives doing with this time? Are they asking more questions? A little bit, not much. They are mostly using their additional time to make comments. So that means that the way that the Chief Justice was running arguments in the telephonic context was to give more time to the conservative justices to make their advocacy, to make their comments and put forward their conclusions. And actually, the liberal, 3 of the 4 liberal justices actually got less comments than they did previously, even though there was so much extra time. So it was a pretty big effect in terms of this ideological impact. And note that just importantly that in all these graphs, Justice Breyer is down the very bottom. He's the one who's losing out the most in the new cases. Remember that for when we look at gender. Okay, this just shows these are the cases that were in the telephonic cases in 2019 term. In every single case, we saw the effect. Conservatives got to talk more than the liberals. But we can also see if we look at specific cases, this is the case Little Sisters about access to contraception based on religious beliefs. Justice Alito, this is just one side. This is just respondent. So the side that Justice Alito voted against, he got to speak for 16 minutes just to one side of the case, compared to the average justice was talking about 4 minutes. So in one of the most politically salient cases affecting religious access, objections to women having access to contraception, that he just got to talk and talk and talk, okay? And so that mattered in terms of how that case came out as well. All right, the final point I want to make, and I'm going to stop and we can have questions after our break, is to look at interruptions again. And it says here, back to gender. Okay, so we've got 3 categories here. This is called a justice being cut off, is when a justice is actually being interrupted by the Chief Justice. The Chief Justice is the only one who can do interrupting now because everybody has to wait for their turn. An advocate being cut off by the Chief Justice while they're talking to a justice, or what we call a takeover, when a justice basically lets the next justice start speaking. Okay, so you can see that only 3 justices were interrupted by the Chief. They were Alito once, Breyer once, and Sotomayor 6 times in 10 cases. So Justice Sotomayor was being interrupted 3 times as often as the rest of the court put together by the Chief Justice. So even though we're looking at very few cases, I think that's pretty significant, and it follows that trend that we saw earlier, that Justice Sotomayor gets interrupted the most. Even when there's only one person who can interrupt, and that's Chief Justice Roberts, he's doing it a lot to Justice Sotomayor. Now you might think, well, that's Justice Sotomayor, that's not gender, because look, Justice Kagan and Ginsburg didn't get interrupted at all by the Chief Justice, as did most of the justices. However, let's look at how that dialogue was cut off by the Chief. So when the advocate is cut off by the Chief while they're answering a justice's question or responding to their comment, then that's kind of like the interruption, a justice being interrupted as well, and that the dialogue is being cut short. If you look at the men, they all have this nice triangular shape. Very few to none of the justices being interrupted, a few more advocates, but overwhelmingly the justice gets to choose when the next justice takes over. And every single man has that triangle shape, even if the top bar is actually empty, which is even better for them, right? Roberts, Thomas, Kavanaugh. And note, Justice Breyer has that nice triangle shape as well, right? But look at the 3 women. Almost as many times that the advocate, their dialogue got cut off as they got to choose when to take over. Same thing for Justice Kagan. And for Justice Sotomayor, not only is she being interrupted 6 times as often, the advocate is being cut off more often than Justice Sotomayor chooses to end her discussion. And that's not, remember, Justice Sotomayor was not speaking any more than anyone else. She was speaking less. Justice Alito was speaking the most, but he got to choose when a justice took over. So here it looks like gender, right? Because Justice Breyer, remember, was treated the worst on every other score. But when it came to interruptions, he's not a woman, he's a man. He's not a liberal, he's a man, right? And so these interruptions are done by gender, not by ideology, overwhelmingly. Okay, I'm gonna, no, I've got a couple more. That's right, sorry. If you'll bear with me. In the 2020 term, we've had a quick look at the numbers so far. Justice Sotomayor is actually talking more. She's managing to figure out how to manage this. And the Chief Justice is actually, we wrote these results up as well as in a research article. We wrote them up in the Washington Post and got a fair bit of attention. So maybe the Chief Justice is trying to be a bit more even-handed now. But in terms of female representation in advocacy, it's still very poor. So here's the number of words spoken by the female justices, female advocates versus the male advocates. Now, obviously, there are a lot more male advocates, but that's not really rebutting the fact that there's a problem. And a final way, I promise this is the last slide, we look at that is, let's take the 3 most common names in any given term. Here we've got Jeffrey, David, and Michael. The most common male names, and compare them to how each female advocate gets to speak. And that's just sort of a, you probably know the statistic that that there are more CEOs called John than there are female CEOs, and the same thing for James. We were sort of trying to do the same thing with the number of Jeffreys, Davids, and Michaels appearing before the court compared to the total number of women. All right. Here are the sources. Obviously, you're not going to take those down, but if you go to SSRN, Social Science Research Network, and put my name in, you can see all of the articles laying out all of this evidence in greater detail, but much easier. As Anil mentioned, SCOTUS OA is my website that looks at this and many other aspects of empirical analysis of Supreme Court oral argument. And the year in review posts for the end of last term have a lot of information if you're interested in more. Okay, I'm going to stop there and then look forward to answering your questions and hearing your comments.
Okay, thank you very much. That was fantastic, Tonja. We're going to have a brief interlude now. We'll show you some slides or some images and give you a chance to start collecting your thoughts for questions that you can post in the chat box. While we're doing that, there's a chance for you to support the Society. Contributions can be collected virtually at ethicalhumanistsociety.org/donate. Or if you want to use Zelle, you can send a donation to donate@ethicalhuman.org. It's through the generosity that we show how meaningful the Sunday programs are. We suggest a donation of $5, but that's neither a ceiling or a floor. We appreciate anything you can spare. We're grateful for all those who sustain the Society with their donations of time and money. So we'll take a brief break and we'll be back in a minute. Okay, thank you. So we're going to go through as many questions as we can. We'll try our best to get through all of them. So let's go ahead and start. Here's the first one, Tonja. It says, presumably it's feasible, but perhaps unlikely, that I interrogate the person I'm skeptical of, but she persuades me by her responses. Is there evidence of votes changing so that the time spent suggests that the person starts out as a foe, but ultimately is convinced and becomes a friend?
That's a good question. So I actually had the chance to ask Justice Sotomayor like what she was doing when she was asking questions at oral argument, and she said, "Well, what I do is I go into oral argument with, I've read the briefs and I have an inclination as to which side I think I'm likely to support or oppose, and so I spend my time asking really tough questions of the side that I think I'm in favor of to see if there's any weaknesses that I haven't thought of." And I thought to myself, I'm pretty sure that's not true, because I've listened to a lot of oral arguments and I'm pretty sure they're spending more time questioning the side that they ultimately disagree with. And so I started doing my empirical analysis. And meanwhile, I had the chance to ask Justice Kagan what she was doing the next year. And I said to her, look, this is what I asked Justice Sotomayor. And it's just like her answer was just not supported by the empirical evidence. So what are you doing? And Justice Kagan said, in a really, I appreciated really frank discussion, she said, look, I'm the most junior justice, as she was back then. And when we go into conference, everybody gets to speak and say how they're going to vote in order of seniority. And so I get to speak after everybody else has said how they're going to vote. And so I don't have any chance to convince them. So what I'm doing at oral argument is often I'm talking to the other justices and I'm saying, look at the weakness of this side that I don't agree with. And so what I'm doing is she's sort of admitting that she's advocating, but she's advocating to the other justices to try and get them to change their mind. And so I think that's right. That's what we see a lot of evidence of. And, implicit in that is that she believes that some justices are open to persuasion. And I think oral arguments do actually serve a purpose in that often justices are influenced by them. And there is empirical evidence to show that the justices are persuaded by, for example, the quality of advocacy. So one of my co-authors, Tim Johnson, did some analysis of this and showed that the better the advocate, the more likely you are to swing the justice. Now, it's a smaller effect than just ideology in terms of, can we just predict your vote in terms of who appointed you or how, what your ideological score is. But nonetheless, it does matter. So the reason we go through all this, the reason the justices are advocating is that they're either talking to the public, like trying to influence the public discussion, or they're talking to each other and trying to influence the other justices. So I do think that implicit within the question is, can justices change their mind? And I think the answer is yes, we do see that. But they're usually the ones who aren't doing as much talking in the case. They're listening. So one slide I will show you, actually. I'm pretty sure I've got here. Just let me jump through. So if a justice... here we are, opinion writers. So this is the same graph that you've seen before, but instead of looking at the usual division, we look at the solid circles are whether the justice wrote an opinion of some kind or another. It could be a majority opinion, it could be a concurrence, could be a dissent versus not. And you can see it didn't used to be significantly different, but now this white gap means there's a statistically significant difference. The justices who write opinions of one kind or another are talking more during oral argument than the justices who don't write opinions. And so that means that the justices who have the strongest feelings are trying to persuade each other. And presumably the reason they're doing that is because there is room for persuasion. So the long answer is that I think justices are persuadable. Whether they convince themselves or not is possible, but it's hard to explain this very significant, highly statistically significant and very substantial difference that the justices are so often persuaded by talking more to the advocate they decide against, but then we shouldn't be finding a result if that question is right. Then we should see, well, they switch their vote, and so they do talk to one side, but they end up voting for that side. So the person they're talking to, if they convince them, should show them, should convince them, and then we'd see more numbers in the agree category, like that they're talking more during the time of the person they ultimately agree with, even though they went in expecting not to agree with them. So it's possible, and I think if you go to SCOTUS OA, for example, we do an in-depth analysis of the first ACA case and show that the Chief Justice really did look like he switched his vote and show that empirically. But generally, I think that's not the explanation, because we wouldn't be finding the effect that we find.
Okay. Rather than female justices learning to speak like men, is there any evidence of the male justices learning to speak like women? In other words, waiting their turn to speak instead of interrupting?
Well, that's a great question, and I am actually doing analysis on that at the moment. Have things changed? So Justice Sotomayor said that after our article came out showing that the female justices are interrupted so much, that two, I think, of the members of the court actually apologized to her, and that she thought things were getting better. And this was sort of, back in 2018. And so what I want to do is do analysis to show whether there has been a shift. And there is some evidence that there is a shift, particularly the Chief Justice has, when he controls the floor a little bit, and I can talk about how he does that, there's been some evidence that he's helping the female justices out just a little bit, but not much. But no, to be honest, there hasn't been, like we can see in the interruptions rates, that there's still this gender differential even between the justices. So I don't think that there's much evidence that the men are improving very much. Maybe they're improving a little bit, but in terms of like the polite language, no. Like men just come in. Almost every man comes in speaking at this very low rate of politeness and stays that way. And it's the women who change.
Okay, it's a program feature, not a bug. Here's a question on this closely related point. Is the use of time and other rules totally at the discretion of the Chief Justice? And are there other periods that appear to have had such strong ideological disparities in the use of court time?
So normally, when we're not in the telephonic hearings, when we're just an in-person oral argument, the Chief Justice has some power, but not nearly as much as he has now. So the Chief Justice essentially introduces the advocates, and then when people are talking at once, sometimes he steps in. So we heard an example of that where he stepped in and said to the advocate, stop interrupting Justice Sotomayor, essentially. But usually he doesn't say, okay, it's so-and-so, it's your turn to talk. The justices just come and speak when they choose, when a question arises that they want to take issue with, or they want to make a comment or what have you. And so the Chief Justice chose to hold the pandemic cases by telephone over the objections of the other justices, and chose for the justices to speak in order of seniority, which means he always goes first. And he just sort of, it's not really written that he gets that power, but he chose to do that. But normally the chief doesn't have that much control, but he tends to just step in when there's sort of too many people talking at once. But as we saw, he's actually using his discretion quite a lot in the telephonic cases, much more.
Okay. You offered to give your theory of what was going on with Sotomayor being interrupted so much more than everybody else. Do you want to take that up now?
So my feeling in particular why the Chief Justice is interrupting, well, so there are two questions things. One is why the Chief Justice is interrupting Justice Sotomayor so much, and the other is why does everybody else interrupt Justice Sotomayor so much? And I think part of it is, I think that it's not just gender. I think it's also race. It's the fact that she's Latina. You know, a lot of people would say when I started showing my initial results, it's like, well, Sotomayor speaks so much and she's so aggressive and so on. I'm like, well, the numbers really don't support that. Justice Sotomayor doesn't speak all that, you know, particularly, like she's always in the top half of who speaks, but she's not usually the most verbal. And so it's this perception that Justice Sotomayor is very talkative when she's actually not. And that's a common response to gender studies. Like people, there's this trope that women speak more than men. And in every single sphere of life, scholars have shown it's not true. Whether it's in group conversations, one-on-ones, between women, between men and women, you know, women talk less and women interrupt less, but everybody interrupts women more. Right? Even women interrupt women more than they interrupt men. But it's just this trope that persists. And so I think partly Justice Sotomayor is maybe seen as, you know, people think it's justified that she's interrupted so much. In relation to, even though it's not, the numbers don't support that. And I think part of that might be our sort of expectations of Latinas as well as of women. But the Chief Justice, I think it's slightly different. I think that there might be some gender effects and there might be some race effects. But I think it's also that Justice Sotomayor asks different questions to the other justices. And the Chief doesn't like the sort of questions she asks or the comments she makes. And in particular, Justice Sotomayor is one of the few justices who talks about race, who talks about poverty, who talks about the reality on the ground about how Supreme Court decisions actually affect you know, different groups differently. And I think Chief Justice Roberts is very formalistic. He believes in, you know, just being racially blind is going to fix racial problems in America, right? He believes in just let's just not consider race at all and everything will be okay, which, you know, people have different views on that. And Justice Sotomayor is asking the sorts of questions that he doesn't think are judicial, right? Because she's bringing up things like, well, this is going to massively impact poor people or, you know, people of color and what have you. And I just think based on his jurisprudence and his approach, you know, his personal philosophy, he doesn't think that they're appropriate judicial questions. So I've never written that because, you know, I can't show it, but that's just my interpretation from, you know, listening to him and reading his opinions.
I see. In the first audio clip where Kagan admitted that Sotomayor was helping the advocate, was that supposed to be a dig at Sotomayor? And does Kagan do less of that sort of helping?
Do I have a picture of this? Every justice does it. So even Justice Thomas, who speaks barely at all, if you look at you know, the differential between who he speaks to and who he speaks more to the people he disagrees with than the people he agrees with. So even when you're hardly talking at all, he's still doing the same thing. Every justice does it. Some justices do it more than other justices. I don't have the slide here, but it's on SCOTUS OA to show how each justice does it compared to each other. Justice Kagan does it. I can't remember if there's a meaningful difference between her and Sotomayor. Yeah, I think it's a little bit of a dig at Justice Sotomayor. Like maybe, I remember listening to that oral argument thinking Justice Sotomayor was doing it a lot in that case. But in the article, here, I'll pull up my sources. In the article where we really explore this, called The New Oral Argument, here it is. We show that everybody does it, but that yeah, I think Justice Kagan was having a little bit of a dig at Justice Sotomayor, but you know, I think it was lighthearted. But in here we go into detail about just how every single justice shows these trends. So Justice Kagan is not above, you know, the thing that she was making fun of.
Another question. What are we to make of the fact that there are 6 Catholics on the court and no explicit secular representation?
I mean, my personal view is that that's very problematic, and we're seeing that in the jurisprudence that's being developed. So it used to be that the court very much promoted both aspects of the freedom of religion cause, like the freedom from religion, as we like to think of it, no establishment of a religion by the state, as much as the free exercise of religion by the state. And in recent years, it's been very, very uneven. Like there's been very little regard for the non-establishment clause, and there's been a lot of promotion of the free exercise clause. So we can see that, for example, in the case I referenced before, the Little Sisters case, and a series of cases like that where the court stepped in and said, it's fine for, public, for companies, for actual, proprietary limited companies who have separate legal entities, so they can't be sued, for example. But we're not going to respect separate legal entity when it comes to them saying that the company has the religious beliefs of, the people who run the company, right? And that they can impose those on their employees such that women can't get access to contraception, which we know is vital to women being equal participants in the workplace and the ongoing strength of the GDP of the nation, right? Even if you don't care about equality, it's massively important to, our wealth as a nation that women have access to contraception, right? That's all not important because these companies, these artificial companies have religious views that they can impose on their employees. And I think that is just one example of the sorts of decisions we're seeing coming out of the court. I think it's only going to increase now. With the entrance of Justice Barrett onto the court, we have a very, very strong and highly religious conservative majority on the court. And I think we can expect that direction to go even further. I think the Catholic influence in particular is very strongly down that path. So we have, we've had some Jewish justices, for example, but the tendency is for Judaism to pay less of an influence on, the extent to which religiosity is promoted by the court. And I think Catholicism seems to be more of a clear influence in terms of, translating not just to what the individual beliefs, but their willingness to sort of impose that on the nation.
Okay. Here's a question from somebody who just read Adam Cohen's book, Supreme Inequality. The question is, how many of the justices as successful members of the upper middle class might be or are many of the justices as successful members of the upper middle class inherently out of touch with the American public?
Yeah, so often people ask, when I sort of show questions where I break down by gender and ideology and so on, people say, well, what about race? And what about, socioeconomic status and so on? I'm going to say, well, we just don't have much variation on those elements. The justices come from this very elite group. They're generally, almost always nowadays, have been judges on an elite court previously. And, before that, they had very successful careers. They almost all come from the same handful of law schools, the Ivy Leagues and so on. And so, they're all, there's variation in wealth, but they're all very upper middle class. And I think that is reflected. Oral argument is one area where you particularly see that because the sort of questions that are being asked are just, there's very little concern about economic inequality. As I mentioned, Justice Sotomayor asks those questions. And Justice Sotomayor had, a slightly different experience. She was a prosecutor, so she's sort of seen firsthand, a different side of the law than just, corporate takeovers and so on. But yeah, I think that there is definitely a problem in that respect. How that can be fixed is very difficult because it's sort of by nature of, the career path that leads you to being a justice. But I do think that is where representation becomes really important because while it's not guaranteed that people of different groups, are going to necessarily have the same concerns. So, for example, Justice Thomas is African American, but he's extremely unconcerned generally with the effect of race. So there's no guarantee. But if you bring, research shows that if you bring in people from different cultural backgrounds, then that will cause them to ask different questions and lead to more complete answers, even if they're all going to be realistically from largely the same socioeconomic state. So, in terms of background, so Justice Thomas, for example, grew up quite poor, whereas Justice Souter was, his stipend from the court was just, play money. So there is variation in that respect. But by the time you're a justice, everybody's doing pretty well. But I think cultural representation is the best that we can hope for.
Okay, here's a statistical question. What do you do about having such small sample sizes when you're trying to do these gender comparisons? I mean, are there questions that you can't really ask just because the samples are so limited, or?
Yeah, so the biggest area where this has caused problems in the past, and one of the silver linings of the appointment of Justice Barrett, in my opinion, is that now we have variation between gender and ideology. So, the fact that we've now had 5 female justices. And, Justice O'Connor was conservative, very moderate conservative. We've had 3 female liberal justices, and now we have a very, very conservative female justice. And so at least that will help statistically for me to show, so going forward, for example, is Justice Barrett going to be interrupted to the same level as the female liberal justices have been? I predict that she will be interrupted more than the other conservative men, but she will be interrupted considerably less than the liberal women, because there's an interplay between ideology and gender. And that's because, Democrats tend to care more about gender representation than conservatives do. They believe in it as a principle. And so we've seen much more representation of women on the left. But it has caused a problem in terms of disentangling those 2 effects in particular. So yeah, it can be difficult. Generally, you try not to analyze just, by individual justice. You look at votes, for example. So we have, 70 votes a year. So statistically, that can give you a bit more detail, but it still comes down to, you still only have very few women on the court to study.
What's the mechanism or mechanisms through which your research could lead to more equitable treatment of the justices? I mean, are there tangible steps that could be taken that would correct some of these things?
Well, so one thing I've done in recent years, particularly, people are really quite interested in this oral argument analysis, and so one of the things I've done is I've tried to always write an op-ed every time, or multiple op-eds in major publications like New York Times or Washington Post, when I write an article to draw attention to it. And I pretty much always say yes to doing presentations like this, partly because I love hearing people's, questions and feedback and how it goes down, but also because it puts this research out there and makes it part of the broader discussion. So what I've found is that, the best thing you can do is to get public attention to your research, and that can have a potential effect. Now, that's one reason I really want to do this follow-up study that I'm in the middle of, and looking at whether, it's kind of hubristic in a way to say, did my article have an effect on the Supreme Court? But at the same time, I really want to know, because, if you're just shouting into the abyss or if you're actually having an impact. There was one of those articles where, Justice Ginsburg commented, and I know that, the Chief Justice Roberts was aware of it. And so maybe it can actually have an effect by, getting people talking about it. The justice, when I wrote the new oral argument, on the other hand, which criticized all the justices for being advocates, none of them started talking about it. But that doesn't mean they didn't read it. It still got attention, got written up in various forums. And so, whether that's enough to stop the justices, really advocating for a position they believe in, I think that's harder. But I do think that it's quite possible that this oral argument in the time of COVID article, that it's still forthcoming, but as I mentioned, there were op-eds about it. I think that might have had some effect, because we do see in the 2020 term the Chief Justice running them differently. And I haven't done the empirical analysis yet because I just have to gather it. But we do plan on doing a follow-up. And I think that might have had an effect, and he might be being more fair because he's subject to this scrutiny. And so that's really important. But, it's like little gains, I think you have to focus on. You can't expect to come along and sort of, change the court. Conservatives are still going to be conservative, liberals are still going to be liberal. And, it's a political institution. So you're fighting against some pretty big institutional incentives.
So a lot of the recent appointees have been somewhat extreme ideologically. Is there much evidence that people moderate once they're actually on the court and having to see the consequences of the decisions that they're taking?
So there is work on this, but it's very problematic work. So and that's sort of a little bit sort of getting into the weeds, but essentially people try and measure the ideological positions of the justices. And there's one group of scholars who said, oh, look, we can show that Supreme Court ideology changes every single justice since 1950 or whatever year it was, like has changed their ideological position over time. Some go left, some go right, some go left and then back to center or whatever. And it's actually, I think it's very problematic because it's a product of the way that we met. How do you measure judicial ideology?
Yeah.
You look at their votes and you see who's voting with whom, right? And so it's the thing you're looking for change in the very thing that you're measuring, which is supposed to reflect, the underlying problem. So that doesn't really work. And the other thing is the way, because the court as a whole can change. So we know that the court has shifted very far to the right? We've seen since Warren Burger was appointed, and then all the justices that followed have been overwhelmingly conservative, and the court has moved to the right. And so then there are justices like Justice Stevens, right, who looks, compared to the rest of the court, like he's really moved way left. But actually, he said, no, the court's just moved around me. I used to be moderate, and then they just kept appointing conservatives. So, of course, now I look very liberal. And so it's very, there is this view of sort of judicial drift, it's called. And it's not statistically very sound, I'm sorry to say. And it just doesn't comport with what we know, which is that the court has changed, and there's no explanation. Like the assumption built into the measures they're using is that the court stays the same, and we know that's not true. And so it's very hard to show. One thing I do, so people used to say that the Chief Justice Rehnquist moderated himself when he became chief in 1986. And when I looked at I don't think I have this slide, but once again, it's on SCOTUS OA. When I looked at the politeness language, I also looked at the Chief Justices and their use of polite language. And we can see a real shift in Chief Justice Rehnquist when he went from Justice Rehnquist to Chief Justice Rehnquist. His use of polite language massively increased. And that to me is like, it's an indirect measure, but it shows that he was moderating his language, if not his actual votes. And so that's something. That's one of the few exogenous measures, like where you're not just looking at votes to figure out how they're voting, right? It's not going into both sides of the equation. But it's not, you could be very polite, but still be extremely, ideological. So it doesn't prove it, but it is just an indication, given that people already said, look, he changed his behavior and he became more moderate.
I don't know, maybe this is just the conventional wisdom, but what do you think Justice Barrett will have any particular effect other than just changing the mix to be 6 conservatives and 3 liberals? Is there some particular area of the law or kinds of cases that you think her presence on the court is going to influence?
So one thing I think that she might change is just by the mere fact of being a woman and being conservative. There is research to show that the gender makeup of a panel, like a panel of judges, is affected in certain areas by having a female like in the group. So there might be sort of somewhat of a legitimating effect for conservative positions by having a female conservative justice. So, a lot of these conservative positions are kind of bad for women in terms of, like we talked about, access to contraception, access to abortion, employment discrimination cases, various other affirmative action and so on. And so she could just have that she could make it easier for the conservatives to be very conservative on those issues. In terms of specialization, it's not clear she was a constitutional law scholar when she was a professor before becoming a judge. And so she might have an influence on those cases. I think we talked about religion. I think she's going to have a big effect on religion cases. But other than that, she doesn't have that much of an area of expertise beyond constitutional law, which sort of all of the justices have, strong opinions on those issues. So it's not clear that she's going to, like Justice Ginsburg, for example, was very liberal, but, quite conservative in intellectual property, right? And so, there's nothing that we know about Justice Barrett yet that's sort of idiosyncratic in that way.
Okay. One of the graphs you showed the number of cases over time, and the court's now taking many fewer than 100 every year. What do you make of that? Is that you said part of it is just conservatives lean towards leaving stuff alone. But is there anything more to it than that? That the pace makes it so low?
Sorry. At the same time, the justices have more clerks to help them write the opinions. So, it's not a workload thing, except that, the justices get flown around the world to give speeches and do other things in their spare time when they're not writing cases. So, it might just be, Judge Posner wrote an article basically saying, what do judges maximize? The same thing other people do, and that includes free time over work. So it might just be a product of that. I do think it's part of a conservative movement as well to take fewer cases, to have a less powerful Supreme Court is it's more laissez-faire if you don't have regulation by a third branch of government. And the fact that, that we see this drop off, here's where where Rehnquist became chief, and we see this the biggest part of the shift happened after that, up until, the early 1990s. It means that there's a lot of areas that are left unresolved by the court. Like, the court is really failing to address a bunch of issues. So take criminal procedure, for example, as an area that's close to my heart. We have all these cases on the death penalty every year, and that's obviously important because someone's life is at stake. But we have millions and millions of people in prison where there's absolutely no regulation by the court on, what is a proportional and acceptable sentence, right? What is cruel and unusual in sentencing? Is sentencing someone to prison for life for very minor things, is that constitutional? And the court's sort of given, free hand essentially to prosecutors and to legislatures to, impose those sorts of punishment. And as a result, we have this mass incarceration. And so that's just one area where the Supreme Court is just failing to lead and failing to lay down law, because it's choosing, partly I think it's because it's not taking enough cases, and then partly because it doesn't want to address those difficult issues. I actually wrote an article called Supreme Irrelevance, and it was about how the Supreme Court avoids all of the tough questions in criminal procedure. So all of the rules that shape policing and prosecutors. So, essentially we have a bunch of rules on how trials are run, but, less than 1 or 2% of cases go to trial. Most cases, there's plea deals between prosecutors and defendants. Practically no regulation on that, right? So they're addressing the most irrelevant issues to the average person facing the criminal justice system. And I could give you a list of examples, but I won't, unless you want me to, of areas where the court is just failing to answer the issues that are most pressing. And I say we particularly see this in terms of criminal justice, but there's lots of other areas as well.
Okay, so we've got time for, I think, maybe 2 more questions. Well, I have a friend who's a legal scholar who is telling me that she thought that one of the biggest changes that's coming down the road is likely to be more cases that assert the idea of a unitary executive, where the president can rule over all kinds of things. So the Consumer Financial Protection Bureau case was, I guess, a landmark in that area. Do you think that will continue? Is that trend something that we should expect to see more of?
I think it depends what happens electorally. So, the unitary executive theory essentially began during the Bush administration, the George W. Bush administration, pushed by conservatives, particularly the Federalist Society. It was actually started by one of my colleagues, Steve Calabresi, who's a great professor. He started the Federalist Society, and he sort of developed this idea of the unitary executive. And the unitary executive theory says essentially Article 2 of the Constitution just says the president is the executive, and therefore the president can do anything. And we see that Trump takes this to extremes, and he literally argued before the court that he could shoot someone in the head and could not be held accountable, at least while he's president. That's an extreme version of it, but it's a pretty extreme position. It became, interestingly, less popular among conservatives when President Obama was in office. And so, will it be pushed more? I think, to the extent that we see a sort of realignment, and that we expect to see, 7 million more people voting for Democratic presidents, if we see, if we see DC and Puerto Rico become states and a much stronger majority for the Democrats to win the presidency, then maybe there'll be less of a push for that. I think it's a conservative position because it's anti-government regulation on executive power. Traditionally not, right? That was not small c conservative, but in terms of current conservative position, with the Republican Party, we might see more of it, but I think it really depends on who's in charge as to whether they think how much power the president should have.
Okay, and so this will be our last question. Do you have any thoughts on the prospects for major reforms of the court? Do you think there's any chance that we'll see any big changes?
The first question is what's going to happen on January 5 in Georgia. If we see 2 Senate seats go to the Democrats, then it's a possibility. If we see them go to the Republicans, then there's no possibility in the short term. There's no way that the conservative Senate is going to let anything happen to the very, very conservative, not just the Supreme Court, but this huge number of appointments that's been made in the federal courts at every level. If the Democrats do win the Senate, then I think that there's going to be a lot of pressure, particularly from the more progressive wing of the Democratic Party, towards reform. But it's a tricky question because Democrats generally believe in, the protection of the courts and judicial independence. And so if they do court reform, if they do obvious court packing, then that raises concerns about, is the Supreme Court and the federal courts generally going to become just this political football that depends on who's in charge, and there's not going to be real judicial independence. So there's definitely a cost to doing so. But at the same time, if there's not court reform, like the Supreme Court at the moment is so conservative, not just on these issues like that get a lot of attention, like abortion and religion, but the Voting Rights Act is being dismantled by the Roberts Court. They've already struck down parts of the Voting Rights Act, despite being voted on by multiple Congresses and repeatedly affirmed. I think that the Roberts Court, the plan is to continue to dismantle the Voting Rights Act, and that means that it's going to be very difficult to have true democratic processes at play. Like a lot of the problems that voter suppression and so on that we've seen in recent years, if the Voting Rights Act if there continues to be attrition of the Voting Rights Act, then those problems are going to become worse, and the extent to which the US is going to be an effective democratic system is going to go downhill. So I think just in order to control that effect, forget about all the other issues, there really is good reason to want to reform the court, but on the other hand, you're going against a principle that you believe in as well. So it's really difficult, but nothing's going to happen unless the Democrats win the Senate. And if they do, then we'll see. I think there's a possibility, and I think there are reforms that need to be made, even if you don't want to do court packing. But I think the biggest concern is that the Supreme Court's going to make the democratic process, which holds all this accountable, less effective.
Okay, thank you. That's kind of a grim way to end, but there you have it.
Maybe Democrats will win the Senate, and
okay.
Maybe it won't
be. All right. Well, thank you so much. That was fantastic. Now I'm going to end with some closing words. These come from Scott Shane, who's a reporter at the New York Times. And he observed that President Gerald Ford was never one for second guessing, but for many years after leaving office in 1977, he carried in his wallet a scrap of a 1915 Supreme Court ruling. The scrap said, "A pardon carries the imputation of guilt, and the acceptance of a pardon is a confession of it." So thank you very much, and we'll see you next week.